Jill and Stacy Show.
Judge Brueggemann is here. I would think most all of you would know what a treasure we have in Judge Brueggemann. Trusted and reliable judge. And it reminds me when we see the news, it's so upsetting to see these out-of-control rogue, lower-level federal court judges rule with these nationwide injunctions against the legal executive orders of President Trump. And so that always reminds me, we just seek justice. We just want truth and justice. And we've got that here with Judge Brueggemann. So we're so happy and pleased to have him here. There's just a few strong points for him. He's an originalist judge. He doesn't believe in a living, breathing document like some people try to claim the Constitution is, and it is not. And Justice Scalia one time was asked if it's a living document. He said, no, it's dead. I don't know if you described it that way. But Judge Brueggemann bases his rulings on the facts presented in the case and not on his personal opinion or biases. He holds true to relevant laws and legal precedent. You can be certain that he will be fair and impartial. Judge Brueggemann respects the rule of law, which then ensures everyone is treated equally under the law, and his decisions are predictable and consistent. You can have confidence in the integrity and impartiality of Judge Brueggemann and his court proceedings. So that's it. Good. Thank you. Come on forward, Judge.
Okay. Well, first, I want to thank everyone for being here to listen to me. You've all been great to me, and I just have to give a little legal disclaimer. As a judge, I'm not allowed to advocate any position that may indicate how I might rule on a case that could come before me. So, nothing I say tonight is meant to telegraph on how I will rule on any issue that would come before me as a judge. The only thing I can say, and I can say honestly, is when I rule in a case, my only intention is to adhere to the oath of office that I took to uphold our constitutions. That much I can tell you. As to the question as to whether or not I agree with Justice Scalia, he's my favorite of all time Supreme Court Justice. I met him, I got to spend 3 days with him, which was really awesome. But I would answer it differently. I actually was invited. Some of you that are here might have been at the debate that I'm getting ready to talk about. I know Senator Schickel was there. I was invited by the Federalist Society, which, by the way, I was a co-founder of the Federalist Society that got it started at Chase Law School. And when I was nominated for president of that organization, it was Brian Richmond who said, I'm nominating Brueggemann for this because I think he'd be the best person for president here, and mostly because there's no such thing as an anti-Federalist Society, because that's what he'd be all about. He was correct. Anyway, I was asked to host or to be involved in a debate with one of the professors at Chase Law School on the topic Constitution, Living or Dead. And I thanked them for the opportunity. It was a packed auditorium, and it was packed because they provided lunch to all the law students who would come and listen to the debate. Senator Schickel came because he must not have had anything to do that day. He wanted to eat too. But I started out by saying, I have to disagree with the title. I think the title is not completely accurate, Constitution, Living or Dead. And I said, what it really should be is Constitution, Fixed or Mutated. It was Professor Vickers that I was debating, and he actually said, I wouldn't quibble with that. And I was pretty sure when he said that I won the debate. And anyway, that would be how I would define it. I think we have mechanism in there for amendments, but it is a fixed document. And it does not mean what 5 members on a committee or body that we like to call the U.S. Supreme Court say that it means. So I'm getting ahead of myself. I guess we'll talk about the First Amendment. I wasn't completely sure what part of the First Amendment you would be most interested in. Who interprets the Constitution? Anybody want to answer that? Who do you think whose role is it to interpret the Constitution? Somebody said the judiciary? No, it's yours. It's yours. They will teach that it is attorneys and judges, that's their job to interpret the Constitution. I respectfully dissent. The Constitution is written in clear language that is meant for the common person to understand. Judges adjudicate laws under the Constitution. We adjudicate, we shouldn't be interpreting, and we should not be saying it means something other than what it says. So, how do we know what it means? Anybody? How do we know what a provision in the Constitution means? Because words mean things. It's one of my favorite phrases. My staff attorney laughs at me a lot. She said, you use that a lot in your orders. She said, but I've come to really like it. Words mean things. That's why they're used. And these are the words. I don't need to read it to you. I'm sure you've read it before. But there are essentially 5 things that the First Amendment protects. And there is, in particular, one phrase in here that I think I would really like to stress.
There you go.
Yep.
That's, I think, the key to understanding the First Amendment. So the First Amendment does not create or give rights. Does that surprise anybody? With the First Amendment, the founders of this country did not give us any new rights. They did not even intend to say they were giving us any new rights. Instead, it recognizes and protects pre-existing rights. Because it starts, Congress shall make no law respecting. That is impliedly stating these rights already exist. You're not going to touch them, right? It's not saying we're going to give you these rights. And so it says Congress shall make no law prohibiting or abridging, so it's pertaining to the rights that are already existing. So my question is, if it didn't come from the founders of this country, who we love to revere, where do these rights come from?
God, they're an inalienable right.
I think we're probably done. That's where our rights come from. It is stated in the Declaration of Independence. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights. That says right there where our rights come from. Now that was debated at the Constitutional Convention, where our rights come from. And we know who won the debate because it says so. Okay, so where else, this is about the First Amendment, so I'm getting a little bit down the primrose path here, but where else in the Bill of Rights does this apply? And what I mean is, where else has it been recognized that the Bill of Rights does not give any new rights? And there's been 3 times in U.S. Supreme Court decisions that different parts of the Bill of Rights have been singled out and stated. Framers never gave any new rights there. These are recognized as being pre-existing. Can anybody else guess what other amendments that applies to? Second Amendment. The right of the people to keep and bear arms shall not be infringed. So it's talking about a right that already exists. Isn't it interesting that they would be talking about a right that already exists when, at that time, not everybody had that right? As a matter of fact, that's why we went to war with Britain. The last straw that broke the camel's back was what? They sought to confiscate rifles and powder and shot at Lexington and Concord. Remember, that was where they drew the line. They were taking everything largely up until that time. That's where they drew the line, and they said, no, across this line we will not go. That was the final straw. So they had already, the government had already pretty much ruled that everybody didn't have rights, and everybody did not have the right to own weapons. Can anybody guess or know Catholics were prohibited from owning weapons because they were papists and they went to the papist mass. So it was a capital felony to go to mass, and capital felons were not allowed to own weapons. They could purge the felony so that they didn't have to be hanged if they paid enough money to the Church of England. But they were not allowed to own weapons. So that's how it was at that time. So isn't it kind of strange that they would say the right of the people? They still recognized that they had those rights even though government was saying they didn't. That is key. Because an inalienable right, what's inalienable mean? Can't be sold, can't be transferred, can't be taken from you. So if the government tells you tomorrow, or today, or yesterday, that you do not have the right to communicate something you have the right under the First Amendment to do, what does that mean?
Taking away your right.
Are they? Can they?
Not legally.
What can you do about it?
They can stand up to court and tell a judge something.
Therein lies the rub. Morally, legally, they cannot do it. Your resistance can be risky. But an unjust law is no law at all. Here's another one, the Fourth Amendment. The Fourth Amendment is another one of the rights where it was recognized that the law pre-existed our government. The right of the people to be secure in their persons, houses, papers, and effects. Now, I want to ask you, was that right recognized by England at the time of the Revolution? Of course not. You've heard about the writs of assistance and general warrants, but yet they're saying here that right was pre-existing. U.S. Supreme Court decisions actually agree with me on this. Okay, so is the First Amendment applicable to the federal government, or the state, or both? Originally, it applied only to the federal government. It did not apply to the states. So, for example, where it talks about Congress shall make no law respecting the establishment of a religion, that means they couldn't say, this is the religion we recognize as being the truth. States could do that legally, if they chose. For example, Maryland could have said, this is a Catholic state or a Catholic republic. You could have had Massachusetts say, this is a Puritan state. We recognize the Puritan religion. If you happen to be on the wrong side of the line, you can vote with your feet. That's the way it was intended. It was changed based upon the 14th Amendment. And it was changed significantly later. 1939 was the U.S. Supreme Court decision that said the First Amendment is going to be made applicable to the states through the due process clause of the First Amendment. So from that point on, the federal government said you had to give these minimum rights to the states. Now, that didn't mean states could not give greater rights. They could say, we're going to give you more rights than the First Amendment gives you, but they could not give you less. So, regardless of that fact, however, it wouldn't have changed anything in Kentucky, because Kentucky, Section 1 of the Constitution says, all men by nature have certain inalienable and inherent rights, among which may be reckoned the right of freely communicating their thoughts and opinion, the rights of assembling together for redress of grievances by petition, address, or remonstrance. It also gives you freedom to worship. And that's the key freedom in the First Amendment, is the freedom to worship. You have a duty to do that. And again, that cannot be taken from you. Anyway, back to the First Amendment, because that's what we're here about. Congress shall make no law respecting an establishment of religion or prohibiting a free exercise thereof. So, for example, let's say someone's declared a viral pandemic and it's Easter Sunday. Y'all seen that movie before, right?
Yeah. Read your paper.
Or of the press, or of abridging the freedom of speech, which is more important in my opinion than the press. So they can pass no law abridging the freedom of speech, or the right of the people to peaceably assemble, and to petition government for a redress of grievances. Congress may not touch that, nor now may the states, through salute the flag. That was held unconstitutional. The opinion was by Justice Jackson. Anybody know anything about Justice Jackson? Justice Jackson was the justice who was picked to be the head prosecutor at the Nuremberg trials. For instance, he said if there is any fixed star in our constitutional constellation, it is that no official, high or paid, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. So that's what he held when he said that was unconstitutional. I think the words of the Constitution are clear. I'm just saying what he held. Here is a case that I find particularly interesting, and that's why I put it in here. Laird versus Tatum. Anybody ever read anything from Laird versus Tatum? Probably so. So this is where what was going on is the Army in particular, and the CIA and other federal agencies were infiltrating movements during the Vietnam War era that were trying to get us out of Vietnam. So they were infiltrating them, and they were actually, in some instances, acting as agent provocateurs, trying to bring charges against them and undermine those efforts. Now, however you feel about, some of those groups were horrific. Some of those groups you might have to ask, okay, how much was it the actions of those groups or actions of agent provocateurs? But across the board, that was what the federal government was doing to shut down those groups' efforts. Were those groups engaging in free speech? That's the question. So the suit was brought, and the infiltration was the claims by the plaintiffs were that it had a chilling effect on the anti-Vietnam War efforts. Now, I think you would agree that would be a chilling effect. You know what a chilling effect is? Chilling effect, we'll get to that a little bit more. I'll show you a little movie clip that'll say it better than I could, as to give you an example of what I think a chilling effect is when government does things to shut you up. But the court denied the case. The court denied the claims. They rejected it and they dismissed it, regardless of how you might feel about some anti-war positions taken. They said they lacked standing. Generally, standing means you do not have enough of an injury to come to court. Well, if you have a group that was indisputed, had been infiltrated by Army and CIA, looking over your shoulder, all of that kind of stuff, trying to get ways to charge you with something to shut you down. I don't know. I kind of think that's, but often you'll see cases are removed when it's, they don't want to address the issue on grounds of standing. So, court dismissed. So, I asked before, what is a chilling effect on free speech? This is a clip. Anybody here seen the movie Night Crossing? I highly recommend the movie if you've not seen the movie Night Crossing. So what's going on here is, this is East Germany, when it's still before the Berlin Wall came down. He's talking to his dad and his dad's friends, and he's saying, would you sign this petition to condemn the traitor, Herr Mueller, as an enemy of the people? And the one says, we already signed that at work. He says, well, sign it again and be twice as patriotic. And they're walking away, and they're all disgusted about it because they think highly of Herr Mueller, who defected. And the one says to him, why are you doing this? This is such a waste of... And he says, well, wouldn't you know they'd honor me with this? I'm the only one in the class who's read all of his books. And so they're going over the issues in the bar, talking about how terrible it all is, and what they're dealing with, and how frightening it is. And the response to students who are called out on that, or who object, or then sent to, fight on the Russian border, or to protect the Russian border, or whatever, or sent to prison, and how the courts are a joke. All of this is being stated in here. And I wish you could hear it, because it is really, I think, impressive. I'll paraphrase it. So they end up finally getting out of the bar. He's driving his son home, who was not passing around the petition. And he's the one saying, we've got to get out of here. We have to do it for our families. He said, every man in here has already had his bag back. Meaning they want to get out. They want freedom. And he gets in the car with his son. And his son is complaining. he said, how are things at school? And he says, about the same. And he's complaining, and he says, Dad, will it ever change? And he stops him when he's in the car, and he says, now I want to make something very clear to you. You can say how you feel to your mother or to me, but to nobody else, ever. Do you understand that? And that is, to me, the most powerful way that I can think of to communicate to you what a chilling effect is on free speech. When you are concerned enough that you're going to tell your child, you can say this to your mother, or you can say this to me, but to save our family, you better not ever say it to anybody else. That is a chilling effect on free speech. So unfortunately, you couldn't hear the clip, the music, the background. The actors are far better than I am. I tried to do my best. I tried to give you a clip. Laird versus Tatum, the dissent. Now, I'm not a high fan of the justice who wrote this dissent, but I give credit where credit is due. And this dissent, to me, is one of the most powerful things written in our United States Supreme Court jurisprudence. When the court rejected that case for standing, this justice wrote, "Those who already walk submissively will say there is no cause for alarm. The Constitution was designed to keep government off the backs of the people. The Bill of Rights was designed to keep agents of government and official eavesdroppers away from assemblies of people. When an intelligence officer looks over every nonconformist's shoulder in the library, or walks invisibly by his side in a picket line, or infiltrates his club, the America once extolled as the voice of liberty heard around the world no longer is cast in the image which Jefferson and Madison designed, but more in the Russian image." That was written when the USSR was still going on. I think that is a very powerful dissent. I think it was very well said in that case. There's consolidated evidence as Edison Company of New York versus Public Service Corporation Regulatory Commission. And that commission prohibited political and controversial inserts in bills. I used to work for a company, it was a family company. They used to put political inserts and sometimes religious inserts into the bills. This case, they challenged it. And the Consolidated Edison Company challenged it, and the Supreme Court held that it was unconstitutional. They said it was content-based. That they were saying you could not put certain flyers in your mailers based on the content. That violates free speech. So if the government is choosing what message you may give, that's content-based. Do you understand what content-based means? And so it was not a permissible regulation, and it was stricken. Rankin versus McPherson, this is 1987. A constable who was like a police officer was fired because he expressed glee about the assassination attempt on Ronald Reagan. He was fired for that. They sued. The U.S. Supreme Court held that it unconstitutionally burdened speech. Now, I'm not saying I endorse everything the Supreme Court says, obviously. I'm not giving you answers. I might tell you sometime I agree with the dissent, or they said that the First Amendment protected that employee from discharge. I think sometimes it might matter what role you're in or what you're doing. And, I would more, if I'm ever in doubt, I'm going to come down on the side of liberty. That's just the way I'm put together. But I have to admit, I couldn't help but say, wow, Scalia has such a gift for words. Scalia's dissent said, "A man should not be allowed to ride with the cops and cheer for the robbers." I just thought that was kind of well said. Texas versus Johnson. That was the flag burning case. Everybody remember the flag burning case? That was where someone burned the flag in protest. And we got pictures of flag burning. We got pictures trying to, people supporting the flag to save it. I put a picture up here that I actually have hanging in my courtroom. It's a picture of, one of the patriots during the American Revolutionary War that had ripped down the Union Jack and cast it to the wind and was putting up the Revolutionary War flag. So the Supreme Court held it was unconstitutional. That struck at the heart heart of a lot of people. How can you not protect our flag?
Agreed.
And so I was torn on that. But something was said in the dissent, or not in the dissent, there was something said in a concurring opinion, and Justice Scalia later quoted it, that I thought was pretty powerful. And they said, okay, we're discussing here, is this the kind of expressive speech that is covered under the First Amendment? The question was, can one imagine the framers of our Constitution burning the Union Jack as a form of expression? The question answers itself, because we can see that, right? We can see the founders of this country being so infuriated with what England is doing that they say the symbol of their nation, the Union Jack, no longer represents any of the freedoms that they're supposed to hold and lighting them on fire. I can see that being expressive. So I think it made a good point. That was one where going into it, I was like, no way, there's certain things you have to protect. A lot of people died for that flag. They really weren't dying for the flag. They were dying for what it represents. And so, I thought that one was really interesting.
Tough one.
It is. You see the point though, right?
Oh, yeah, I see the point. It's a tough one.
Keller versus State Bar of California. Lawyers were compelled to join the Integrated Bar Association and pay dues to support it, even though it promoted views to which some members objected and were beyond the purposes of the bar, such as gun control. I got an extra L in there for good measure. That one was held unconstitutional. You cannot force somebody to join a club like that and pay for things that you are conscientiously opposed to. And I would go further than that. You took an oath to uphold. And there you are undermining it. So I very much like that one. They said the bar may not espouse views such as gun control that are beyond the purposes of that organization. Now, how much that fixed it? Another question. RAV versus St. Paul, this had a city ordinance that prohibited fighting words, but only such fighting words that insulted someone on the basis of race, religion, color, creed, or gender. So in other words, if someone insulted your mother, you couldn't defend it. The court held that was content-based and they couldn't do that. They couldn't make it based on viewpoints. Now, you're going to see this changes, right? This doesn't really jive with a lot of the hate-based laws, right? This was earlier. In this decision is where it said sticks and stones might break my bones, the words may never hurt me. That was how it used to be. And remember, how do we know what First Amendment means? What does it say? Words mean things, right? The text. So, anyway, this is just further explaining it. And again, I'm just reporting to you what the case says. I'm not necessarily subscribing to what it should be. So this is Boy Scouts of America versus Dole. Everybody in here remember what that was about? So the state's public accommodations law compelled the Boy Scouts to accept membership of LGBTQ, in particular for a scoutmaster, I believe it was. They refused, they fought it. That law was held unconstitutional. They said it would significantly affect the group's rights to expression. They said it violates the right of free expressive association, and cited Hurley, which was the St. Patrick's Day parade, similar. A bit more recently, everybody know who that is? Okay. Now, we know the role he played, and he's trying to pass it off on somebody else, and you're probably glad now that the sound isn't working. But he was being interviewed here on Joe Rogan, and he was talking about why he caved in, saying he shouldn't have caved in, but he did cave in, and was talking about the pressure that was put on him. So, for whatever it's worth, that's what it is. I'm not taking the position that he really is a lizard man. That's for you to decide. I'm not saying he is or isn't. So out of that, and you can see this is very recent, 2024, Murphy versus Missouri. 2 states, elected officials in those states, and individuals having social media accounts sued for having their content suppressed by social media companies. And they sued because they said this was done on orders or They were prohibited from reporting reports of vaccine injuries, even if they were true. They were prohibited from posting election misinformation.
Yep.
And that was regarding 2020 and the 2022 midterms only. The district court ruled, that's the trial court in the federal court system, that court ruled that the actions did violate the First Amendment and issued an injunction. The Eighth Circuit Court of Appeals affirmed that decision, said, yep, you got it right. Injunction stands, you're violating their free speech. The U.S. Supreme Court, in an opinion by Justice Amy Coney Barrett, reversed and said, no, hold up, these plaintiffs lack standing. They can't come in here arguing this to us. They've not shown enough of an injury. They haven't shown enough of a connection to the federal government to prove that the government was the actors behind this.
Yeah.
Sure.
So, I've gone over all that. Justice Alito, Justice Thomas, and Justice Gorsuch dissented strongly. And they said, quote, this is one of the most important free speech cases to reach this court in years. Freedom of speech is essential to democratic self-government, end quote. Government officials may not coerce private entities to suppress speech, and that is what happened in this case. So says those three justices. Many government actors and a variety of internet platforms were involved. They called it voluminous evidence proving effects of those interactions on 7 different plaintiffs. And then some of the details these justices gave was there was the reports of a rare blood clot caused by the Johnson & Johnson vaccine, found in trials but was not released. And Tucker Carlson covered this. And so these 2 instances in particular were demanded by the FBI, by CDC, by President Biden's administration. They demanded these social media companies said Tucker should be deplatformed, not just demoted. So they can demote your video so it gets less views. They said that's not enough. You need to deplatform this guy. I don't know. You tell me. Violation of the First Amendment or not? Is that free speech? Is that content-based? Is this enough coercive activity to be a chilling effect on free speech? Is there standing?
People don't respect the government anymore.
When the White House did not get the results it wanted, it quickly turned to virtual demands. And these are quotes. This is coming from the dissenting justices. Then they turned to threats to social media companies, accused them of fomenting insurrection, compared it to January 6th. You all know what that means. They reminded them that Biden, quote, supports a robust antitrust program, end quote. Accused them of killing people. Now, when a federal agency like an FBI or the White House is telling you this, is that a chilling effect? I mean, as much as you might like or dislike Zuckerberg, do you know what I'm saying when you're having that kind of arm twisting put behind you or a gun put to your head? And then the FBI Biden administration told these companies they were not taking any options off the table to punish them for noncompliance. Okay, so there's that. You all remember that. Even more recently, and I'm not saying how anybody should feel about this, but if you're familiar with anti-boycott laws, there's some cases that have not gone to the U.S. Supreme Court. There's Coons versus Watson. It's a U.S. District Court case in Kansas. A public school teacher was required to certify that she was not boycotting Israel. She refused to certify that, and her contract was not renewed or extended on that ground. She sued. It was held unconstitutional in lower court, saying it's what? Content-based. Do you agree?
Yep.
It doesn't matter whether you agree with her boycott. Does she have the right to say, I'm not going to buy products from this country because I don't like what they're doing?
Right. She has
If it was England or Russia or you name it, does she have the right to say, I am not going to buy? Can you, if you're a public agency, say, I'm not going to hire you now because you won't certify that you will not boycott? How? I mean, I'm just asking you. I'm not saying how I would come down if that case was in front of me. it free speech or not? So that ended up being mooted before it went to the Sixth Circuit. They basically worked it out. The General Assembly there, I think, changed the law so that it could not result in her being terminated from her employment. And so it was mooted and didn't go up the chain. The Sixth Circuit had already accepted the case. In Jordahl versus Bronovich, similar thing. Lawyer refused to certify that he would not boycott Israel. The Arizona jail that had hired him to be their legal counsel refused to rehire him or renegotiate his contract on that basis. Same result. There was Arkansas Times. It's a Texas case. Newspaper. It was actually a newspaper that had a contract with the university. They refused to certify against boycotting. They said they had no position one way or the other about a boycott, but they wouldn't make that certification because they said they thought it violated their right to free expression. That if they wanted to associate for or against any group, they should be able to do it, or any country. So they refused, and their contract was canceled. This time, however, was an opposite result in the lower court. Where it ends up, I don't know. But what's very recent, and maybe bringing something up about Trump at a Republican Party meeting, I don't know. Did anybody see Trump's recent threat to require anti-BDS laws? Anti-BDS means boycott, divestment, and sanctions. Yeah. And so what Trump said recently, and I've been told that if you go to the Wayback Machine or Internet Archive, you can see where Department for Homeland Security or FEMA had already had provisions on the website that they would not give. So Trump said, any states that do not have anti-BDS legislation or laws will not receive any federal disaster relief or assistance for any disasters that happen within those states. Supposedly that was already on FEMA and Department for Homeland Security's website to do that. Now, like I said, I'm not making a ruling here. I'm asking you, First Amendment's written for you. I'm not asking you how you feel about boycotting another nation. Is that constitutional to make that demand? Is it constitutional to pass a law that says you are not allowed to boycott this country? You are not allowed to boycott companies that are in that country. Is that a violation when government says that to you of your First Amendment right? So, real quick, I don't know where I'm at on time. I'm trying to be quick, but how are our rights protected? Maybe let me put it this way: what's the best way to protect our First Amendment right or the other rights? Is it the Constitution? Is it the courts? Ideally, the answer would be yes.
Yeah, ideally, but
Ideally.
that's not the case.
But is the parchment protection that the courts are supposed to enforce enough? What I'm going to show you next, these are provisions. I'm going to tell you what these are. I'm not going to tell you where they're from. Well, you're going to see. I'm sorry. I gave you the punchline. It's right in front of you. These are taken from the Constitution of the United Socialist Soviet Republic. This is their constitutional provisions, Article 50. In accordance with the interests of the people and in order to strengthen and develop the socialist system, citizens of the USSR are guaranteed freedom of speech, of the press, and of assembly, meetings, street processions, and demonstrations. See, they have similar protections. What's different here?
Separation of powers.
Exactly, but if things can happen here to mow over your free speech and you're afraid to say or do anything about it, what's different really? And if our separation of powers are not respected anymore, for example, if one branch of government can usurp the powers of the other three and get away with it,
Yeah.
do we really have separation of powers? Because Senator Schickel's 100% right. Our Bill of Rights is really, Justice Scalia said this, and at first I was shocked when he said it. But the more I studied and looked into it, that was 20 years ago I first read that. He's 100% right. The Bill of Rights really is an impressive sounding thing that's sort of a last fallback. But our real protections are in the separation of powers. That is the baked-in protection. We're supposed to be separate. It's what these systems didn't have.
Right.
So ideally, the courts should stand in and say, absolutely, you can't do that. You can't put this person in jail because he violated your law that he couldn't protest, or he couldn't assemble against this, or he couldn't boycott this company. That's ridiculous, right? So, but that's what their Constitution said. Do any of us believe that they were allowed to do that?
Oh, no.
They were, if it supported the Soviet viewpoint, right?
If it was on their party line.
Exactly. And isn't that what we're seeing in a lot of the laws?
Oh, yeah.
Whether you're Republican
Both
or Democrat,
sides of the
both
road.
parties?
Both
Both
sides of the
sides.
road.
Yeah.
Both sides. And then it goes on, exercise of these political freedoms is ensured by putting public buildings, streets, and squares at the disposal of the working people and their organizations by broad dissemination of information, and by the opportunity to use the press, television, and radio to proclaim their message. Do you believe it?
As long as you're following their guidelines.
And it goes on. This is just more of the same, and giving them freedom of religion, even though they murdered, I don't know how many Christians over in the Soviet Union. Anyways, that's just an important thing. You can see what ours says, but ultimately, the protection of our rights should not be left to parchment and paper, and shouldn't be left to guys like me, although you should expect that guys like me should be held to uphold their oath. I made that promise. It's not that I made it to you. What scares me is I made it to Almighty God. And I do try. I'm not going to tell you I always get it right. I do say a prayer every morning, and I hope you all will pray for me that I do get it right. Because sometimes it's difficult, and sometimes I might not get it right. And sometimes I don't like the outcome. I have a class that has asked me to come back now for 8 years straight. It's a class over at Cooper. I'm really surprised. That teacher is a glutton for punishment. He's going to come back every year. The students will come into my courtroom, and sometimes they have attorneys that are chaperones. And one year they had a couple of attorneys chaperoning them. And one of the students asked me a question, and she said, "Judge, how often do you have to make decisions that violate your moral code or your moral viewpoints?" And I said, "Never." I said, "As a matter of fact, I would never make such a decision." And you could, especially on the faces of some of the chaperones, they were aghast at that. How could that be fair? How could that be right to the people that you would make such a statement? I said, because our laws are only just if they coincide with the moral absolutes. There are moral absolutes. There is such a thing as truth. In this business that you have your truth and I have my truth. Pardon my language, that's bullshit.
Amen to that.
There is such a thing as truth. And if I could not take an oath, if I didn't believe that our system was premised such that laws had to be just and the outcome, I couldn't wear the robe. I couldn't take that oath. Now, that doesn't mean that there aren't decisions I have to make that I don't like the outcome, or decisions that I have to make. But when you apply the law and the facts, you might not like the outcome, but it should never go against the moral code. It should never go against moral absolutes. And I quoted St. Thomas More, who said, "The statesman who will forsake his private conscience for the sake of the public duty will lead his country by a short road to chaos." And I believe that completely. And so I asked them, if there's no such thing as moral absolutes, if there's no value system that is true, then how could we have places we call courts of law or justice centers? How could anybody, if the law really is survival of the fittest, if that's the true law, if we're going to subscribe to Darwin's theory of survival of the fittest, and you have somebody come into court and they get under oath and they commit perjury because the outcome for them is better, how could you ever accuse them of committing a crime? How could that be wrong? If that's survival of the fittest, how could you hold them to account for that? That makes no sense. How could their value of life be less than mine? Unless we do like Justice Oliver Wendell Holmes, who I told you who my favorite Supreme Court justice of all time was? I'm going to tell you he is my worst, the one I like the least of all time. He basically held that the true power in law in government is might. If you have power of coercion, people must obey, and that is the ultimate authority. That's what he held. And at the Nuremberg trials, just as a little tidbit, when Justice Jackson was there as the head prosecutor, and they were prosecuting German doctors in Germany and judges, they were prosecuting them for war crimes, for crimes against humanity, wasn't really war crimes because they weren't fighting. And they were prosecuting them because they were sterilizing forcibly individuals. They were ordering it to be done. They were euthanizing. Do you know who the defense counsel for those judges and doctors quoted verbatim? Justice Oliver Wendell Holmes in a case called Buck versus Bell, when he ruled that it is the ultimate obligation of government to get rid of those useless eaters, those people in society who are not productive, who are not helping the state, and I'm paraphrasing, but where I'm not paraphrasing, and I'm going to give you pretty much an exact quote, is when he said, 3 generations of imbeciles is enough. And he ordered Carrie Buck to be sterilized. Yep, that's who they quoted. So I would hope that the irony was not lost on Justice Jackson. Anyway, that concludes my presentation. I probably went too long.
Just a little bit.
Sorry about that.
Is the modern definition of speech potentially incorrect? And the question is, do people have the right basically to say anything, including an untruth? And a caveat that I give on that, this is the thought process, I've been thinking about this a little bit. So basically, if rights pre-exist the Constitution and they come from God, and God is all truth, the opposite of God often referred to as the great deceiver, could you argue that no one has the right to speak an untruth, but maybe as a society we tolerate it because of the gray area?
Okay, what I would say there, and that's an excellent question. First, I would say, morally speaking, no one has the right to do wrong. And even in law, no one has the right to do wrong. The problem you get in with speech is, who is going to be the arbiter of what's true? We had, under the Biden administration, we had Obama recently saying we need some kind of agency who would be like the arbiter of truth, that would decide what's misinformation and what's not. I mean, unfortunately, when our government makes a declaration about something that's true, if I don't have time to research it, I can usually assume the opposite is true.
Affirmative.
Yeah.
And then that's the result. And you find out that you're, I don't know what percent, whether it's 90% of the time that works. So it's who gets to be the arbiter now. If you say something that's untrue, there are ramifications. There's such a thing as libel, and truth is an absolute defense to libel. So I would not be in any hurry to change the fundamental principle of our rights to free expression and free speech because some people abuse it. I think the best antidote to a lie is the truth. The lie will get around the world 3 or 4 times before truth gets its shoes on. But truth usually will obliterate presume that people would speak the truth. But, we couldn't trust government with that. That's that's why the First Amendment exists, especially, this situation. I hope that answers the question. Did anybody else have a question following up on that? Or not like my answer? Any other questions? Yes.
The part where it was they wanted to not give disaster relief to if they had anti-whatever.
It was President Trump said he would not give disaster relief to any states who did not have anti-BDS legislation.
Okay. How is that any different from the complaints he made when FEMA wasn't giving aid when people had Trump signs in their front yard?
Right.
That is a very good question.
That's no different.
Very good question. I think that gets back to Oliver Wendell Holmes. I have might, I have power, so I am right. I don't think there's any difference personally. I think it's content-based. I don't like your message, so you're not going to get any of this assistance. I like your message, so you're going to get extra. That's what I see it. And what country is that more like? The USSR, not the USA.
So how did the governor of this state get away with closing down our churches if he was breaking the First Amendment?
So, I addressed that in an order that I wrote.
Yes, you did.
And I actually quoted the U.S. Supreme Court for the premise to say that an unjust law is no law at all. And when you have the right to worship, government cannot stop you. And they can't use a vague law to stop you. And therefore, the people have the right to continue doing this anyway, even if I do not issue this injunction. Unfortunately, they're going to take risks by doing that. There is a certain point, I'm trying to remember who said it. I think it might have been Martin Luther King Jr. who said, we have to stop. He was talking to the black community when they were organizing, and he said, we have to stop doing what the losers have been doing to lose and start doing what the winners do to win. And they did some things that really did change some stuff. And part of it is, if they said all churches have to be closed arbitrarily and without basis in law and without following, you know what I mean? If they unconstitutionally again declare all churches to be closed, ideally, all churches would open up on Sunday morning, just the same as they always do.
Oh, yes.
And there wouldn't be enough jails or prison cells to hold people. That's the American spirit.
But the chilling effect, which you just showed us, the chilling effect is that they're taking down our license plate numbers and they're going to arrest us.
And I understand the chilling effect.
So, and I guess my biggest question, I know you addressed it because I read it.
But ultimately, I think what we're getting at, what I'm saying here, isn't First Brueggemann 14.4. I'm not telling anybody to do anything other than don't trust parchment to protect your rights.
Got it.
That doesn't mean you don't engage in risks. And I think there's a Supreme Court decision, I think I quoted it in my opinion, but I think there's a Supreme Court opinion or decision that says that same thing, but they also say, make sure you're right. Because even if you are right, it's possible you could pay horrible consequences for your decision. And, that's I guess, the life of a freedom fighter.